case study. In this video, I am going to go through a case study. Real case study that we won last year. It's about abandonment of lawful permanent residency. But before we go there, I am going to talk about what is lawful permanent residency, ways that you can acquire it, and how to maintain it, because a lot of people acquire the green card, but they don't know that it is imperative that you maintain it or you might lose it. That's why it's called permanent residency. So if you do not know me, my name is I Bijoux Ngwanda. I'm an immigration lawyer here based in DC. I do work with individuals across the country because we're dealing with US immigration laws. And I do have clients across the country dealing with complex immigration cases. If you're new to my channel, please go ahead and subscribe. If you're not new, welcome back. Thank you for subscribing. And please don't forget to hit the notification bell so you don't miss any of my videos. If you enjoy the content, please go ahead and share, like, and don't forget to comment below. And also don't forget to join us on our private Facebook group and post your first question so that we can be able to assist you there as well. Okay, let's get right into it. Ways. There are a lot of ways that you can acquire a lawful permanent residency, the so-called green card. I've talked about it before. I've talked about 25 ways to get a green card. I've talked about 15 ways to really get a green card for filing the form I-360. Well, we've talked about it in length, but today I'm just going to give you a brief overview on how to get a green card. The first way is when somebody comes with a B1 or B2, or maybe the person crossed the border and either get parole or not get parole, but somehow the person applied for asylum because they qualify for asylum. And after the asylum is granted either by USCIS or by the immigration court, the person is allowed to stay in the US after a full year. Basically, after a full year of being granted asylum, the person has now the right to apply for a green card. And then the person applies for a green card, and that's how the person who initially came with a B1, B2 visa or without really inspection, depending on how you got here, and apply for asylum, and then you get your green card. That's one way, the common way for most people. Second way is the DV lottery, which every year people apply for that diversity lottery. They get selected, they go through consular processing to an interview, or some people adjust status here. We've talked about it too. If you're in lawful non-immigrant status and you win a DV lottery, it's really easy for you to adjust status here if you are in lawful non-immigrant status, okay, and otherwise find admissible. You can do that. So that's a second way, DV lottery. Another way is by marriage. People get married to a US citizen or lawful permanent resident, end up getting a green card, sometimes for 2 years if the marriage is less than 2 years prior to filing, or 10 years if the marriage has been for more than 2 years prior to filing. So then you get the green card. Some people get it through work. Okay, work, either they sponsor you by an employer, H1B visa, or you started with E2 and eventually do your self petition with EB1 or EB2 and eventually end up with a green card. So we have humanitarian ways, we have family-based way, and then we have employment ways to get a green card, not to mention U visa, T visa, which counted among humanitarian ways to get a green card. Let's say you get a green card. That was a case for this beneficiary. This is a case of Mr. J. We're not going to say the name because we want to remain confidential with our client. But anyway, this was a case of Mr. J. Mr. J was a beneficiary of his mother green card because the mother was in Canada and got married to a US citizen here in the US, and Mr. J was the son born prior to the marriage, came with the mom, and was a derivative and the beneficiary of his mother green card. Years later, the mother divorced with the husband, and then the mother takes his son, because the son was born, remember, prior to that marriage. And the other children, siblings, they had custody, right? Share custody. And the mother decided to go back to Canada and took his son and went back to Canada. The son stayed in Canada at age, I believe, 7 or 6. No, the age almost 11, sorry, or 10. So young. Went back to Canada. The son stayed there, but the son had contact with the siblings and stuff like that, because the son did not have the age of majority to decide to come back to the US. The son was stuck in Canada. Okay, remember that the son was underage, a minor. Years later, the son decided to come back to the US, and because the green card that the son had expired, the son decided to apply for a renewal, filing the form I-90, which we all know that that's the form you file if you want to renew your green card. While the green card was denied, that was pretty much the story. The green card got denied, and the son came to us to deny. So I have to reiterate, when they sent you a notice of intent to deny, that's when they're really telling you the intention of why they really want to deny the card. And if at that point they don't respond accordingly, that's why you get a denial. That was the case. This guy get a denial because he didn't respond accordingly, and then pretty much he didn't know what to do or what to say. That's why he finally decided to consult with us, and then we were able to file an appeal, right? File an appeal, using the form, the form you use to file an appeal motion to reconsider or to appeal. Anyway, we filed that, and we had to prove that the son did not have the intention to abandon his residency. Why? Because the son had family ties. Pretty much we had to show the email correspondence with the siblings. Then we had to show other evidences, right? We had to show a lot of evidences. The son was trying to get into universities here, try to interview online, over the phone, open bank account, open investment bank account, came with some type of visa, work visa, a 3-month visa, worked here. So we had to show tax returns, file here. So pretty much showed the intent not to abandon residency, and we're able to prove it, right? So we went over some cases. That's what I want to share with you today, because this is a case study. The reasoning is that if you do not understand the language in the letters, either it's a request for evidence letter or notice of intent to deny, or the denial itself, it is better for you to consult with a qualified attorney. You can call my office if you wish to do so, 202-751-2180. Email is bijoux.ngwanda@gmail.com. Consultation fees apply, of course, but we'll be able to assist you and tell you exactly what we think and how we think we can respond. And once you hire us, we can deliver, especially if it's something that we have done before, right? So we had to go through a couple cases. We had to show to USCIS that abandonment of residency can in fact be overcome. because we can show that the person maintained sufficient ties to the United States and never intended to abandon residency. We cited the matter of Wang, and then where the BIA said that the question of abandonment depends on lawful permanent resident intent rather than length of time spent abroad. It's all about intent. What was your intent? We can prove it with ties. We can prove it with anything that you were supposed to be, maybe something that was holding you back over there, or something that you were still doing here in order to maintain ties. So that's how we were able to prove it. Then we cited Caution v. Holder, the Ninth Circuit Court case, where abandonment to a child can be, abandonment of residency of parent can be tied to a child. But unfortunately for this child, they couldn't tie it because the child could not decide. So at the age of majority, the child was able to show his own intent. Okay, and we're able to win this case within 4 months. 4 months, we're able to demonstrate with a lot of evidence. So what is the moral of the story in this case study number 1? I've been doing a lot of case studies. Case study number 1, the moral of the story is this: if you have a green card, you cannot remain outside of the US for a period of time longer than 1 year. If you wish to do so, you must apply for a permit, which says permission to travel. It's kind of like advance parole. So pretty much it's telling USCIS your intention to stay longer than 6 months or longer than a year. Really, you have to show there your intention prior to leaving the US. But if for some reason you get stuck there for reasons beyond your control, extraordinary circumstances, death in the family, serious sickness, and you were just supposed to stay there, then you can show evidence to prove that you went there for something else happened, your intention was still to come back. And with family ties or anything else, we can show USCIS that your intention was to return, because that's the law. The law says that it's rather than the intention is what they were looking at rather than the length of time spending abroad. Okay? This is Bijoux Ngwanda, immigration lawyer, again in the DC metropolitan area. Until next time, bye-bye.